Oh, I love the smell of United States Supreme Court oral arguments in the air. It's the fall. It's the new term. And it's a landmark oral argument today in about 2 hours in front of the United States Supreme Court about the entire framework of Donald Trump's presidency. No, not the lawlessness. No, not the depravity. No, not the immorality. That's for another day. But on the surface, the framework of his domestic and foreign policy, of his economic policy, are tariffs. And the fundamental question, because you'd think it would have already been answered before Donald Trump decided to impose tariffs on, as one federal court put it, tariffs of unlimited duration on all goods on virtually every country, you'd think he'd have the logistics of the legality worked out. But he relied on the slender shoulders of one law, the International Economic Emergency Powers Act from 1977, from Donald Trump's favorite president, say it with me, Jimmy Carter. And that law was passed by Congress in order to rein in a president who was struggling and gurgling under the weight of a collapsing economy, and they didn't want him to do certain things. So they gave him limited powers in the International Emergency Economic Powers Act, IEPA. Now, Donald Trump has distorted the true meaning of the statute of IEPA and its powers and its uses, has tried to turn limitations into some sort of affirmative power. And now it's made its way up to the United States Supreme Court. Yes, the day is here for this landmark oral argument. And I'm going to be looking for several things. I wanted to make this sort of a primer for you to guide you, a viewing guide, if you will, for what's coming up in about 2 hours at 10 a.m. We'll be doing a live feed, live stream under the live tab of Legal AF YouTube channel about it. And then we'll come on with commentary. I'm going to be joined afterwards by Legal AF contributors Lisa Graves, who's written in a tremendous book about the Roberts Supreme Court called Without Precedent, sort of a tip of a hat to our unprecedented, and Adam Klasfeld of All Rise News. But let's get into what this is all about, how we got here, and what I'm looking for, and therefore you should be looking for at the oral arguments tomorrow. Donald Trump came into office and decided in April, at the now infamous day in the what's ever left of the Rose Garden, what's ever left of the White House, to announce that he, as president of the United States, effectively in acknowledgement of violation of Article 1 of the Constitution, which gives the power to lay, collect taxes, and do duties and tariffs and excise taxes on Congress only and not the president. He stood there in the Rose Garden with his Commerce Secretary, Howard Lutnick, with a big board, remember it? With like 130 different countries listed on it. And that it was going to be a unilateral imposition of a tariff on all these countries, on all of their goods for an unlimited time. And people were like, how can he do that? Because he announced it, apparently, and then it led to a series of challenges. Now, there are different ways for a president to impose a tariff of limited duration for limited purpose, but Donald Trump's not relying on any of that. So let's just focus on the argument. The International Economic Emergency Powers Act from 1977. So it went through challenges. There were multiple challenges. It ended up at the court that Donald Trump handpicked. He transferred the case to the Court of International Trade in New York, I think it was longer, I would say 3-judge panel. I think it might have been a couple of judges more than that. They listened to the argument and they decided that as much as Donald Trump would like this to be the centerpiece of his economic policy, that there was no justification for it in IEPA. And that, as they framed it, tariffs of unlimited duration on all goods of every country in the world is not a power that the president has under Article 2. And they struck it down. Now, they stayed their order and allowed him to continue to collect tariffs, which he's used as an excuse. Look at all the money that I've collected. Yeah, but if it's all illegal and illicit, and it's all void ab initio, it's void at the start, then give the money back, which is what he's going to end up doing. Because the American consumer have been paying that imposition of tariffs because it's gotten passed through to them. 70% or more has been passed through downstream into the price of goods. But the importers who paid the amount of money are going to get, $500 billion of a refund. Donald Trump likes to say, look how much I collected. But again, if it's wrong from the start, then the ends don't justify the means. Now, it then went to an appellate court, a specialty appellate court in New York, in Washington, D.C., called the Federal Circuit Court of Appeals. It deals with patents. It deals with trade issues. You probably never heard of it. I've only thought about it probably twice in my entire life before Trump got in office. But that panel, en banc, meaning all the judges, like 12, 14 judges, they voted in a majority to uphold the Court of International Trade and strike down the tariffs. In fact, one of the judges said, the part I love the most, because it's the most accurate from a statutory construction or interpretation standpoint of looking at the literal words of the statute, where's the word tariff? The tariff is, the T word is not even in there. And how do we read it in? We don't. So now we go up to the United States Supreme Court. Finally have oral argument. In the meantime, tariffs are being collected because the Supreme Court has allowed it through blocking of the lower court's decision. And there's 3 or 4 different ways to look at it from a Supreme Court standpoint, the arguments. And when you start hearing the questions, I want you to know which thematic, which stream we're going down. You start with statutory construction, statutory intent. You look at the words literally used by Congress in passing IEPA. You just look at the words on the page. Or as Amy Coney Barrett said in one of her own books, when you're doing statutory construction, read the statute, read the statute, read the statute. Okay, I can read the statute. Nowhere in the statute does it give the president the power to impose a tariff on every country, on every good for an unlimited duration. The tariff word is never used. I think we're sort of done here, don't you? I'm sure we're not, but especially with a Supreme Court MAGA 6 that's bent over backwards to empower Donald Trump. But that should be the beginning, the middle, the end. I mean, if I'm the advocate for learning resources versus Trump, the small businesses who are the lead plaintiffs in this case, lead appellants in this case, I'd look at Amy Coney Barrett and say, Your Honor, as Justice Barrett said in her recent book, you read the statute, read the statute, read the statute. We've read the statute. Then we go to what's called originalism or textualism. And there's been a number of amicus briefs, friends of the court briefs, have been filed by constitutional scholars. There's been more briefs filed in this case than I can think of by friends of the court who are not parties but want to be heard about their analysis. Most of it, the vast majority of it, against the Trump administration position, including a gang of 9 constitutional scholars that wrote a brief that was filed in which they focus on originalism and textualism. And what originalism says is that you look at the words on the page, you read them. And then if, in this case, the Constitution, not the statute, and you look at Article 1 and any place else around Article 1, and you look at the legislative intent, the words of the framers, the words of our founders about the power of Congress to levy taxes and excise taxes and tariffs, and why they didn't give that power to the president. In fact, as one person noted in a recent in an article in the New York Times, Congress was given the power to tax and to impose tariffs before there was even a Treasury Department that was created by Congress for the executive branch, even before they had a place to put the money. It's always been an Article 1 power. Now, the Supreme Court, sometimes I joke about the Supreme Court, especially the MAGA 6, that they seem to have their own version of the United States Constitution. Like I have my own version. It's here on my desk. The Constitution of the United States of America. It also includes from our framers and our founders, Benjamin Franklin, Alexander Hamilton, Patrick Henry, John Jay, and I grab it when I need it. I always joke that the Supreme Court, MAGA 6, they have their own version. It only has 2 provisions, the Second Amendment about guns and Article 2 about the presidency. What about Article 1? What about Article 3, the judiciary? But the problem we have is during this MAGA period of our American history, we have a washcloth, a wet noodle, a doormat of a Congress led by MAGA Mike Johnson, at least the House and the Senate too. And so they should have been writing a brief themselves to file with the court to tell the Supreme Court that they don't want their power infringed, but they won't stand up to Donald Trump that way. So former And members of the House now on the Democratic side and former members of the House have stepped forward to file their briefs too. And when you look at originalism, you say, let's look at Article 1. What did our founding fathers intend? What was their intent? And how do you glean that from how words were used at that time and dictionaries that were used at that time and legislative history and what the framers and the founders said and what they said in the Federalist Papers and what they said at the Continental Congress and wherever, private papers of these people. And you then try to look at this in the world of originalism. They look at everything through amber. You know, the Constitution's been trapped in amber, and the MAGA six try to use originalism in order to have the dead hand of our framers back in the 1700s and 1800s control what happens here. But even under originalism, this should be a no-brainer to strike down IEEPA and Donald Trump's use of it to impose tariffs under a violation of Article 1. So statutory construction, loser for Trump. Then you go to originalism, you loser. And then lastly, there's this fiction that was created, a fictional doctrine that was created by the MAGA right wing led by John Roberts. And we call it the major questions doctrine. And I want to know how quickly within this oral argument we hear about the major questions doctrine. And what that says is that rather than an interpretation of a statute, to expand it, to add a phrase or term or condition or approach that's not actually expressed in the literal language, rather than do that, when it's a major question, a major issue, then we want to hear the MAGA six of the Supreme Court said, we want to hear from Congress themselves. They need to have it clearly expressed in a statute or in legislative history, that this is what they intended. And if we don't have that, we're going to strike down this interpretation as a violation of the major questions doctrine, which is why the Biden student loan forgiveness program was shot down, because they said, well, if Congress really wanted to do that, they're allowed to, but they'd have to express it clearly because it's a major question. How about 138 tariffs of unlimited duration on all goods in the world, on every country? Don't you think that's something that maybe Congress, who has the sole power, unless it's been partially delegated to the president, that they'd have to speak clearly on? They'd have to issue an actual statute that gave that power or put that language in the statute? You'd think. So there's a number of shoals. There's a number of ways that this Trump interpretation of IEEPA founders, right, on the rocky shoals of statutory and construction and interpretation, of originalism, which they're in love with the major questions doctrine, what the MAGA six are in love with. You start with the statute. It's not a power. Now, some people will say, well, what about Ronald Reagan, which is after 1977, when he imposed a tariff or a sanction for a short duration against the Japanese who were flooding the American market with chips, computer chips. And it was threatening to destabilize and put under American chip manufacturing, which is sort of in its infancy, led by Intel. And so even though he's a free trader, Reagan imposed a short-term tariff against Japan because there was no time to go to Congress. There was no time to make this thing work through the halls of justice. He was able to do it under a very short time period. Nixon was too, under a predecessor to IEEPA, but not, I'm going to take over tariffs. It would be like, here, I'll give you the equivalent. And if I was the advocate in front of the Supreme Court, I would do this with them. I would say, Your Honor, let's forget the first Article 1, Congress powers, and Article 2, presidential powers. Let's talk about Article 3, your powers on the judiciary. Okay? Let's bring it home. How would you like it? And would you think it would be appropriate under the Article 3 of the Constitution and the framers' ideal for co-equal branches of government if the executive branch set up its own court system? If the executive branch set up its own court system, had its own shadow Supreme Court, the executive court, that was going to issue its own rulings in competition with Article 3 judiciary. Is that allowed? No, because our Constitution says it's all that power is to be reposited in a judicial court run by us. Right. And all the tariff power is reposited in Congress under Article 1. So he doesn't get to have his own court system running parallel or to replace the Article 3 judges. That's one. And he doesn't get to steal from Congress their power to tariff. I would sit down after that point, but I don't think they will. I think this is going to be an 1.5 to 2 hour hearing. You're not going to want to miss this oral argument. When people are leading it, I'll jump into the chat and tell you who's leading on this conversation. I'll mention these doctrines so that you understand them, and we'll know within about a half an hour which way this is going. And if they do the right thing, applying their own principles, they should be shooting down this tariff policy. And every time Donald Trump threatens Brazil with a 50% tariff because he doesn't like the Trump of Brazil going to jail for his insurrection, which was struck down by the Senate last week, even the MAGA senators were like, that's too far. You can't do a 50% penalty tariff on Brazil because you don't like what they're doing with their sovereignty about their former Trump. So that was a good signal to the Supreme Court. Even the Wall Street Journal came out with an editorial against Donald Trump that said to the Supreme Court, rip away this terrible, powerless attempt to steal power from Congress. You see what he does. He's now punishing. 2 weeks ago, remember, he punished Canada for a while. I think it's still there with a 10% tariff because he got trolled by an ad by Doug Ford of Ontario because he didn't like the fact that Ronald Reagan's own words were being run against him in an ad about tariffs. And the Wall Street Journal said, see, that's a good reason why you want to take that power away from him. Because he doesn't deserve it. He doesn't have it. And you can see what happens with an out-of-control president who has the power of tariffs. You know, we were joking before I recorded here among the Midas Touch Network that because we're about to get ready for, we'd just gotten through with election coverage and we were preparing for it. And Governor Abbott of Texas wrote out a social media post that if Mamdani wins in New York, that he was going to impose 100% tariff on New Yorkers trying to move to Texas. And one of the brothers wrote back, I see, that proves that MAGA and Donald Trump don't understand what a tariff is. Right, I'm going to do a tariff on a person. But join me in about an hour and a half, 10 a.m. Eastern time. Go to the live tab on this YouTube channel. Pick up our live coverage of the oral argument tomorrow on tariffs. Until then, take a moment, hit the free subscribe button. We're already at 910,000. We picked up another 10,000 subscribers who've joined our movement. So important, especially coming off of election night in America, to demonstrate your First Amendment rights, protect our First Amendment rights. And if you want our honest reporting, become a subscriber. Check to see if you are now. Come over to Legal AF Substack. We're running the live on Legal AF Substack as well. If you want to live there for the day or for the morning, and become a paid member if you can for $6.77 a month. So in the meantime, I'm Michael Popak and I'm reporting. I'm Michael Popak, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popak Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popak Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popak Firm today at 1-877-POPAK-AF or by visiting my website at www.thepopakfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popak Firm, fighting for your justice every step of the way.